All right. All right. Hello, everybody. Today we're going to be talking about U visas. We're going to talk about the U visa process, U visa timeframes, and if you have any questions about U visas, you can put those in the chat, or if you're watching the replay, you can put your U visa questions down there. Of course, if it is something that is extremely personal or private, you are going to want to schedule a private consultation for that. So just a little bit about me. My name is April Holloway. I am an immigration attorney, and I have been working in immigration in the DC area for the past 7 years. Before that, I was doing insurance defense. So without further ado, let me go ahead and share my screen with you. All right, here we go. All right, residency via U visa. So a U visa is a process by which someone who is a victim of crimes in the United States will eventually be eligible to apply for residency. It is a process, and there are some steps and some complications that can occur. So we're going to go through all of those today. And at the very end of this, we're going to go through some examples of complications that people might experience when they're seeking a U visa and what we can do about those complications. If you do want to schedule a private consultation with me regarding U visa or any other immigration matters, you can go to my website. It's holloway-legal.com. At the very top, it says click here to schedule a free consultation. So that's where you'll go to do that. So now a U visa requires that you be a victim of a qualifying criminal activity, either in the United States or on a U.S. territory, and that you file a report and or cooperate with the police and prosecutors. So even if you aren't the original person who made the call to the police officers, if you cooperate with the police and prosecutors in their investigation, you can still get a U visa. Let's do a more in-depth look at number one, qualifying criminal activity. These are the qualifying crimes as indicated by USCIS. Abduction, abusive sexual contact, blackmail, domestic violence, extortion, false imprisonment, female genital mutilation, felonious assault, fraud and foreign labor contracting, hostage, incest, involuntary servitude, kidnapping, manslaughter, murder, obstruction of justice, peonage, perjury, prostitution, rape, sexual assault, sexual exploitation, slave trade, stalking, torture, trafficking, witness tampering, and unlawful criminal restraint. Now, while these things are listed as the qualifying crimes, you want to be aware of exactly what the police report says about the crime, because it may not be titled this way and still meet the qualifying crimes definition. For an example, you might have someone who was the victim of molestation. Now, molestation is not listed here, but if you look at the elements involved and what the police report says, it could quite possibly meet the requirements for sexual assault or sexual exploitation or even rape. So you want to look beyond just what the crime is called in your particular state, because they do have different names depending on which state you're in. Also, attempted and conspiracy count for qualifying crimes as well. So the crime does not have to have been completed. If it was attempted torture, attempted sexual exploitation, attempted manslaughter, those are still going to count as qualifying crimes, even though it wasn't completed. Now, cooperation with police and prosecutors. What exactly does this mean? Well, it means that if the police ask you to assist them by providing additional information, you have to be willing to return their phone calls or go down to the police station, whatever they're asking you to do. Cooperation with prosecutors means that you have to be willing to testify in court. You have to be willing to give a statement if the prosecutors ask you to. You have to be willing to answer the judge's question. Now, if you refuse to go to court, there is a potential out there that you could still get your U visa signed off on because you cooperated with the police. But it might be more difficult because the police are not obligated to give you that signature. The prosecutor is not obligated to give you that signature. So they, in their discretion, can say, yes, you cooperated with us, but you didn't cooperate with the other party, so we're not going to sign off on this. And there won't be any appeal process or anything that can be done about that. It is their choice whether or not they want to sign off on that form. All right, so U visas are a 3-step process to get to residency. We did kind of touch on number 1, but I am going to give you more detail about it. So the first is the form 1918B. This is a certification that's signed by the police or prosecutor or victim advocate, anyone else who's involved, to say that you did assist the police or prosecutors in their investigation. There is no time frame for this particular document. So you can give this to the police and they can take a month to sign it, they can take a year to sign it. They're not required to review it and sign it by any particular time frame. Once you have that document signed, then you're going to ask USCIS to designate you as a U visa recipient. That's number 2. U visa application is sent to USCIS. That is form 1918. At this step is where you can add other family members to be designated as U visa derivative applicants. So if you have a spouse that you want to apply for, you have a child that you want to add, this is the time period where you do that. After USCIS agrees to designate you with the U visa, then you're going to receive a letter that tells you the time frame in which you're going to be eligible to apply for residency. You can also apply for a work permit during this time, because there is going to be a wait between when you apply for a U visa, you're designated with the U visa, and when you can officially apply for residency. Once you apply for residency, which some people also refer to as a green card, that application will then be pending and granted. At that point, you're a resident of the United States. So that's the 3-step process for residency. Remember, you can send me any questions you have about that. The time frame on number 2 and 3 does change. You can check USCIS website for their current processing times for those 2 steps. There are some complicating factors in dealing with U visas. This does not mean that you cannot be granted residency through U visa. It just means that there's going to be an extra issue to deal with apart from those 3 steps. So the first one that we're going to talk about is if you have a prior removal order or in absentia order. So the difference is going to be, let's say you applied for asylum, your asylum case was denied, you were ordered removed, and you remained in the United States. So that's a removal order. An absentia order is you were requested to appear in immigration court, you did not go to immigration court, you were ordered to remove without going. So if you have a prior removal order or an absentia order, you can still go forward with the U visa process. However, once it's complete, you're going to have to go back to the court. Even though you have a green card, you're not ready to travel freely yet. You're going to have to go back to the court and ask for them to rescind that removal order and terminate your immigration case. Unless that is done, it is not safe for you to travel on your green card outside of the United States. You will have issues upon return. All right, the second complicating factor is unlawful entry. If you have an unlawful entry into the United States, then you're going to have to apply for I-192. The best time to do that is in step number 2. When you send your application out asking USCIS to designate you as a U visa recipient, you want to file that I-192 at the same time so that by the time you are designated as a U visa recipient, you've already received a forgiveness or waiver of that unlawful entry. Okay. The next complicating factor is if you have criminal history. U visa is a discretionary process. The government is not required to allow you to receive residency via U visa. So if you have a significant or turbulent criminal history yourself, it is in their discretion to deny your application. What can you do to overcome criminal history? Well, number 1, make sure that anything that you were supposed to do regarding that case has been taken care of. If you had a fine that needed to be paid, be sure that fine was paid. If you're required to do community service, do your community service. If you've completed probation, be sure to get a letter saying that your probation has been completed and you met all the requirements of your probation process. And of course, you want to be sure that while you're waiting for your U visa, you have no further criminal contact with the police or have any other issues during that time. You also want to be honest and forthcoming in your application, because if you are not honest about it, that's the fastest way for your application to be denied based on their discretion and review of your criminal history. Okay. The next complicating factor is lack of continuous contact with your attorney. Now, the U visa process is a long process. And so if you at any point change your address or change your phone number, you need to be sure to update those with your attorney as soon as possible. There have been many occasions where people have made it where they're ready for step 3, and because of lack of contact with their attorney, their U visa expires. Then you have to go and request an extension and it becomes more complicated. So remember, this is a long process. You want to be sure that you have continuous contact with your attorney and that they know your address and your telephone number. You may even want to give them a backup telephone number and person to contact if by chance you lose your phone or something happens. Okay. And the last complicating factor is non-compliance with officers or prosecutors. Once you receive your notification that you are designated with U visa, you still have to continue your compliance with officers and prosecutors. So if that case happens to go on that long and you decide you're not going to return their phone calls anymore, that officer or prosecutor may write a letter to USCIS to let them know that you have no longer been cooperating and they want to rescind their signature on your certification. So definitely be aware that this is a complicating factor and you want to continue to be compliant. Now we're going to look at some examples to see whether or not this person in this situation is eligible for a U visa. Number one, CK was working at the gas station when the store was robbed. He does not have a work permit. So is CK going to be eligible for a U visa? So remember our two requirements. One, the person has to be a victim of a qualifying criminal activity. And number two, they have to cooperate with police and prosecutors. Now, the crime that CK was a victim of is robbery. Was robbery on the list of crimes eligible for U visa? No, it is not. Robbery is not a qualifying crime for a U visa. However, what CK should do is take a look at the police report and see if the way the crime is described would meet one of the other categories. During the robbery, was CK pistol whipped or hit, creating an assault, which might qualify for a U visa? During the robbery, did CK attempt to leave the store and was forced to stay inside because the criminal was holding a gun, forcing him to stay inside the store? That might meet the requirements of false imprisonment or hostage situation. So on face, CK might not be eligible for a U visa because the crime is robbery, but when you dig a little deeper, there might be an option. That second sentence, he does not have a work permit, is a throwaway. It does not matter whether CK has a work permit or not. It doesn't even matter how CK arrived in the United States. He may still be eligible for a U visa if that robbery can be turned into a qualifying criminal activity. Number two, GB arrived in the United States in 2013 and was detained by immigration. After being released, he did not attend immigration court and was ordered removed. Last year, he was the victim of attempted manslaughter. Now, is GB going to be eligible for a U visa based on those facts? I'll give you a second to consider it. Take some time to think about it. All right. So the issue here is that GB did not attend immigration court and was then ordered removed. That is not going to be an impediment of GB obtaining a U visa. They will be able to file an I-192 to forgive their initial unlawful entry into the United States. And they will be able to, after the green card is awarded, request for that to be rescinded. Okay. I see a question asking exactly what the U stands for. The U has no particular significance. The visas in the United States they use letters to assign them. B is a tourist visa. H is one of the worker visas. So T is a trafficking visa. That's the only one that actually makes sense, T for trafficking. But the rest of them, they're just random numbers or letters. All right, so number 3. KJ previously applied for residency via his USC spouse in 2015. However, the I-130 was not approved. USCIS did not think he had a bona fide marriage, and he has now been the victim of stalking. So will KJ be able to apply for a U visa? Yes. There is a difference between KJ being found to have committed a fraudulent marriage versus a finding of not having a bona fide marriage. So KJ is not going to be prevented from seeking a U visa as a victim of stalking, which is a qualifying criminal activity. All right. So WB currently has DACA. He was recently the victim of simple assault. Thank you, Ty's Way, for your question. I appreciate it. If anybody else has any other questions, feel free to type them here or let me know on the replay when you have questions. I'll be coming back to the comments to answer them. So WB currently has DACA and he was the victim of simple assault. Okay, so the issue here is simple assault because the eligible crime is felonious assault. So what you want to look to again is the police report describing how the assault was committed to look for ways that you can argue that it was a felonious assault. This state may be calling it a simple assault, but we may be able to argue a gun was brandished, making it a felonious assault, or there was some other element that made it a felonious assault. The fact that WB currently has DACA is a throwaway fact. It does not matter. People on DACA can also apply for residency via U visa. If the person on DACA entered the United States without permission, they're also going to be eligible to apply for a waiver of that initial unlawful entry. If they've used their advanced parole, that's even better. They already have an unlawful entry. They already have an approved entry. So that's not going to be an issue. If you have any other situations that you want to run past me to see if it's going to be U visa eligible, here's my contact information. You can find me on TikTok and YouTube. On YouTube, I also share all of my travel information. If you're interested, my last trip was to Fiji and San Francisco, and coming up, I'll be going to Sweden and Antarctica. So you definitely want to follow and subscribe on my YouTube page so you don't miss that. You can also find me on Instagram and Facebook as well. So thank you so much for attending. I hope everybody has a great day. And